This is Technically Legal, a podcast about legal technology, innovation in the legal industry, and the impact tech is having on the law. I'm Chad Main, the founder of legal services company Percipient, and on today's show, new Era ADR CEO Rich Lee makes a return appearance to tell us what's been happening at the company since he was first on the podcast in 2021, just after it launched. On today's show, my buddy Rich Lee, who's the CEO of New Era ADR, visits the podcast again to talk about the company's cutting-edge platform that's revolutionizing dispute resolution. Rich first came on the podcast in 2021, right as the company launched. In today's show, Rich is going to fill us in on what's been happening at the company since 2021, including the company's mission to provide a faster, more efficient, and cost-effective alternative to traditional litigation arbitration, talks about the company's growth in the last 3 or 4 years, and the lessons that he's learned in growing the company.
To get started, give us a recap of what New Era does for those that might not have caught the first episode.
So New Era, in a nutshell, we are an alternative dispute resolution platform, right? But completely reinvented from the ground up, deliberately to be different from the existing court system and, of course, the legacy arbitration forums. And it was built out of, the kind of shared frustration that my co-founders and I had, especially when the three of us who were in-house and we were GCs of tech companies, the disputes we had to deal with and how we navigated those. So in a nutshell, we are 100-day arbitrations, right? Versus the 12, 24, 36 months that we've all just kind of gotten accustomed to in the courts and legacy, ADR forums, all fully virtual. So virtual first, we're arguably a tech company first because everything takes place on our platform.
When we spoke in April 2021, was the platform developed on launch day, or were you still in the midst of that?
I mean, we had V1. Yeah, that was part of the launch was, platform was built, version 1 was built. It's come a long way. And of course, the rules and everything, the procedures and had been vetted and then in place.
And so the product offerings, virtual mediation, virtual arbitration, which you've already alluded to, it's all online.
Yep.
I assume they're in video and you can upload your documents and all that. So I did notice too, and I couldn't remember, you offer expedited arbitration. Was that offered from the get-go too, or is this something, a new offering?
It was offered, and in fact, that's the default, right? It's
right.
The expedited 100-day arbitrations.
Oh, okay.
Yeah.
Explain how that differs from just your typical arbitration, be it virtual or otherwise.
A lot of differences, right? But a couple key areas are, one, I think the two call-outs I'll make, and then we'll talk about how everything kind of pushes people to 100 days, right? It's a combination of, the people, the procedures, and then, of course, the tech. Procedurally, two of the things are, the way we handle dispositive issues, right? And so just like in any other forum, people can raise dispositive issues, except we don't drop them into a highly formal, kind of motion practice type of process where...
Are motions even allowed?
They are in the sense that you can bring up a dispositive issue at any point in the case. And, we have kind of chat functions within the platform, which is SOC 2 Type 2 secured. So you're in a secure environment. You can bring this stuff up as you're going along. We don't expect people to have to brief both sides, schedule a hearing, and do that over and over and over just to go over motions, right? And so our process there is making it more fluid, allowing the arbitrators who are just as experienced as, actually a lot of them are the same ones who are doing this in other forums too. So they're just as experienced. So we're relying on their experience to kind of navigate these in more of a fluid way. Like if you want to bring up a motion to dismiss or, as the parties present, go through discovery and discovery is closing out. You want to raise, a motion for summary judgment. Bring that up. But we don't need to, have this long drawn out kind of briefing process, hearing process, all this stuff. So that's one. But actually one of the biggest is discovery, right? So we empower our neutrals, like actually a lot of jurisdictions around the world with their judges, we empower them to be able to singularly limit, right, the scope of discovery in the sense that the parties absolutely have two-party discovery, right? Just like at any other forum. They can submit their RFPs, but the difference, for instance, drawing the contrast to like our court system is that, when one side receives, let's use a really absurd case of like, oh, I want 10 years worth of documents and I want depositions of an entire C-suite for, a standard employment dispute. While, in courts and a lot of forums, you're going through endless now motions to quash and compel, and then hearings alongside those, just on each item, right? Trying to limit that. Because, the standard that a lot of these forums use is, well, what does each side think they need to put on a good case?
Yeah, that's what I was going to ask. So let's say you file a claim against me, you want the 100-day, but could be procedural, strategic reasons otherwise, I want to slow roll this, and I want the 10 years of discovery and stuff. What happens then where I don't really want the 100 because it's not to my benefit, but it is to you? Like, what happens there?
Well, then, you know what? We wouldn't be the forum for you. That's the goal with everything we built was, we recognize, hey, there's games on both sides. So even though we came from the corporate world, we very deliberately also put ourselves in the shoes of like consumers and employees, individuals who've been wronged. And it's the same thing. So you have gamesmanship on both sides. You have gamesmanship in organizations who use their considerable resources as leverage, right, to kind of crush meritorious claims against them, right, and force the other side to acquiesce. But similarly, you have gamesmanship on the other side, right? You have a subset of plaintiffs' lawyers, who, let's call it, they do bring a high volume of cases, not really vetting them, hoping to extract the nuisance settlements, right, using the length and expense that kind of built into the court system and legacy, ADR forums, right, using that as leverage to extract nuisance settlements. And our purpose was, what? Let's distill all of this down to, almost like a concept of what's right is right. If you have a meritorious case or defense, you should win. If you don't, then you should lose, right? And so going back to your question, if you're a company or you're an individual who wants to create a 10-year-long process, it's just not going to happen, right? And so we like to say that, there are some cases, there's a really thin layer of like highly complex, bet the company cases that aren't good for the platform, right? Think like trade secret misappropriation cases, multi-billion dollar, joint venture gone awry type cases. So all those cases are ones where you probably do want to turn over every stone because there's a lot at stake. But most disputes, like 95% of them, 99% of them, just don't need that, right? And that was our thesis is we navigated a lot of these standard employment claims.
Go to your thesis. What's your sweet spot? I know we talked about it prior with the more volume stuff, less complex, but are there any new areas where you didn't think was going to be your sweet spot and now that are?
When we launched this, we did always say that it was going to be very industry agnostic and that our belief was every industry, every kind of different niche, right, in our society has pockets of large pockets of these disputes that are, and they're not necessarily low dollar. There's just, they're just standard, right? Like you could have a $5 million breach of contract claim. That's still standard. Just because $5 million or $50 million is at stake, it's still a piece of paper, right? And so for us, that was the thesis. And fortunately, it's been proving out. Like, so of course we launched into, like Live Nation and Ticketmaster was one of our earliest and first customers. That was more of a consumer case. We have a lot of employment use cases. We have a lot of folks using us in commercial. But then what's kind of evolved is really interesting. They're all kind of extensions of these, but different use cases where, right now, like a large automaker has us in all of their warranty agreements now, right? And so all warranty claims against that automaker will be resolved quickly and fairly. The U.S. Olympic Committee actually became customers, right? So they put out a press release last year announcing that, we're their official arbitration provider alongside the U.S. Anti-Doping Agency, right? So we handled all of the athletes' disputes, leading up to the Paris Games. And so that was another niche, right, that we didn't specifically envision, but we knew, hey, it fits into that category and definition of, here's another set of cases where both sides are interested in just a quick resolution. These are athletes who are, trying to live their dreams one time every 4 years. And these are disputes that impact that. And so both sides want to get this right and want to get these done quickly and efficiently. So it's been interesting. Sports, we have Title IX cases, so university disputes, code of conduct issues, right? And so all these different pockets are, they all fit, right, into our platform. And I think that's one of the great things is we designed one set of procedures deliberately to be universal, and then a platform that's highly modular and that we can adapt to different use cases and case types so that it does feel pretty native, right, for like Olympic athletes to come in and they'll see the disputes and terminology that are familiar to them in the platform.
We should point out, too, that the rules you just referred to, the New Era rules, are on your website so people can get an idea of what goes on, how it works. And also, you've got clauses on there. So to those people that do want to build in your offering, your dispute resolution offering in a contract, you got all kinds of clauses there. So going back to the organizations that are using you, how they coming to you? You got salespeople going out there? Are they coming to you, or word of mouth, like a combo of both?
Increasingly more just kind of inbound, but still a lot of word of mouth. And also what's been really helpful is law firms, right? So law firms of all sizes, law firms on both sides, but especially with the ones that are helping companies write their employment agreements or handbooks or terms of use or create policies. We've been really fortunate now, over the past basically 3.5 years since we launched, right, to have many, many firms, many organizations vet us pretty heavily. Unfortunately, knock wood, the outcome of all of that 100% of the time has been adoption or approval, right? And so then what happens is then these law firms, each partner has multiple clients. And so they'll go recommend this to their clients because, hey, one, this saves the clients a ton of time and money, right? Two, this is now a law firm doing the thing that every in-house counsel wants, right? Which is adding value when they're not being called. And so they're presenting these great new ideas to these companies that are actually going to save them up to 90% in time and money, right? Not just 5%. And so a lot of it coming from law firms. We do have a small outbound, sales team, but at the same time, the founders, especially the three of us who are, the former GCs, we're still out there, right? Speaking to many, many customers.
It's a combo of both.
Yeah.
So like, let's say I'm a outside employment counsel or compliance, whomever it may be, putting the company handbook together, the policies. So they're saying to their client, hey, you know what? For these employment disputes or what have you, let's build this into the handbook or the onboarding documentation that employees sign. So you got those, but are you also getting to the more one-off, like commercial disputes or something that maybe otherwise would go to AAA, the American Arbitration Association, but they're coming to you because the lawyers handling those matters like New Era?
So at the time of a dispute, usually we're not even targeting those, right? Because it's harder, right? Because if there's, let's say, another form already written into a contract, yes, you're right. The two sides could theoretically still agree to not use that and come to us, right? But I think it's more of a psychology thing where, once two sides are at odds and they're already in a legal conflict, the last thing they're going to agree to is just to switch forums. Right. Even if one side suggests it, even if it is true that they would save a lot of time and headache and expense, the other side's just, it's kind of just the state of being in a dispute with someone. So no, not those, but we are getting written into a lot of commercial contracts, right? So whether it's manufacturers themselves or the law firms representing the manufacturers, putting us into their supplier agreements, their vendor agreements, a bunch of other companies, right, putting us into their kind of B2B type contracts. So absolutely.
When we come back in just a minute, Rich fills us in on what he's learned in the last 3 years during the time his business has been a going concern, what New Era looks for in neutral, and what the future looks like for the company. I'm Chad Main, and you're listening to Technically Legal.
We need to do more with less. That is the key takeaway nowadays from almost every survey of in-house counsel. But what if it didn't have to be that way? What if you actually could do more for less? By combining legal expertise and technology, Percipient enables legal teams to get more work done for less. Buried in contracts and sales is frustrated with turnaround time? We can help with that. Did you just get hit with a subpoena and reviewing 100,000 documents and files will tax your resources or cost you a small fortune in billable hours? We can help there too. Our team of legal professionals leverage tech and project management principles with the right amount of human oversight to deliver precise, efficient, and cost-effective legal solutions. Whether it's legal operations and contract management support, subpoena compliance, or document review, Percipient is your partner in really doing more for less. Percipient. Legal services powered by technology.
What's one thing that you would have thought in April of 2021, when we first talked about the launch of the company, you thought was going to happen? You for sure thought was going to happen. You thought it was a great idea that really did it. And what's one thing now on September 25th, 2024, that happens you didn't expect, or a learning that you had that you just wouldn't have thought of back then in April 2021?
I think the biggest thing, even though it was something we knew, and it actually answers both questions, is I think we underestimated the need for almost like social proof, right, for lawyers to make a new decision.
Especially for lawyers, right?
Yes. I think people in general, right? Most people don't like to be kind of tip of the spear, right, in adopting any new thing. And we recognize that. And then we also recognize that lawyers are trained, right, to identify in school. We're trained to identify everything that could possibly go wrong, right? And we also recognize that, unfortunately, a lot of lawyers kind of stop there, right? They identify the things that could go wrong, but then they don't kind of zoom out and say, well, how wrong is wrong? Is this actually that bad? Is this, as Jeff Bezos would put it, is it a two-sided door where I can just kind of walk back through, and fix it? And so there, I think we underestimated it. We thought some of the adoption would be faster early on. And we did have some very fast first movers, which was really exciting.
But let's face it, if you didn't think it was the greatest idea since sliced bread and people were going to adopt it, you might not have done it, right? That's the beauty of being an entrepreneur. You got to have some level of just naivete and just maybe complete ignorance, right? Just to do it. Otherwise, you're not going to do it.
Yep. Because it just made so much sense, right?
Right.
To us, it's like, it was just so pragmatic. Like, wait, here is a whole subset, a giant, what we call the 95 to 99% of disputes, where, in our own personal experiences, both as in-house counsel, as litigators, one of my colleagues was a litigator at a big firm for Colin, right? Was a litigator at Greenberg for, I think, over 10 years. Like, in our experience, it's just, we know that most of these disputes don't need these long processes, and more importantly, that both sides, right, plaintiff and defendant, actually are both very interested in getting these things done really quickly and efficiently. And by done, I don't mean like a hold your nose settlement, right, which is what happens today. That's what we call done until we came around was, well, just pay the person, or just take this small amount, even though, this organization really did screw you, to go and try and get what you really deserve. It's going to take 2 years. Right, that's wrong. And so for us, that's so practical that we thought, all right, this practicality should just land. And fortunately, now fast forward to today, which is kind of the second part of your question, we've been fortunate that now with the social proof, with the companies and the law firms that have approved us, the ones that we can mention, right? And then even the law firms that are recommending us, it's chipped away a lot at that, basically that thing that we underestimated, which is, lawyers kind of being hesitant because we were new.
And that's what, they always say is when a law firm wants to innovate, they get together in their committee and they say, well, what's everybody else doing? Who else is doing this, right?
Yeah.
That's what you're up against. So to those ends, how are you communicating your social proof now that you have it? You kind of always had it from the get-go, like, hey, Live Nation's using this.
Yep.
And so how do you communicate it to make these lawyers feel comfortable?
Certainly, privately, we talk through different use cases and potential case studies, always kind of with client confidentiality in mind. We can talk very generally about certain companies, and the types of use cases they have us in without ever naming the company. And so that helps. And then, of course, then you layer that on with like the firms, that are out there actively kind of telling people about us. And then, some of the logos that we can use, then like the press releases that the Olympics put out, or when the Chicago Cubs both like became customers and investors. We did law.com wrote a piece about it. So like pieces like that help. And then you have these organizations, right, where we're just in their public terms of use, right? And so, actually the car company is Nissan, because I can just send you Nissan's warranty booklet and you'll just see us in there. Or you search for it on Google and it'll show up, right? And so a combination of all of that kind of just gives people an idea like, hey, this is actually pretty far and wide. It's not one niche industry. It's not one niche dispute type. It is truly, auto, real estate, banking, sports, entertainment, higher ed.
Well, it doesn't matter, right? Because we're going to get to this, it leads to my next question. You can find a neutral that has expertise in whatever, right? So on that topic, I know you had relationships with neutral organizations when you first launched. Has anything changed about how you were attracting and recruiting solid neutrals?
So we still have those same relationships. Fortunately, they've been great supporters from day one and, are still kind of strong partners in that sense. But the big thing that's changed is a lot of inbound now, right? So neutrals hearing about what we're doing, really liking this. And these are neutrals that we don't ask for exclusivity. So any neutral who is non-exclusive with where they're currently doing cases.
They could be jams or AAA or whatever, right?
Yeah, exactly. And actually, a lot of these folks are still doing, their cases at these different forums. Or, I know in for some different forums they do ask for exclusivity, and so then we have some of their former folks on our bench. So these are the same quality, but then we actually put them through additional vetting, because one of the things that we've always been focused on is user experience. That's certainly like a very kind of tech industry term. But for us, user experience doesn't just mean like the product experience, which we pay a lot of attention to in terms of like what the user flow looks like. Is it accessible? Is it easily understandable? Is it intuitive? But at the end of the day, it's also who our neutrals are.
What are you looking for specifically?
People who, frankly, are just not abrasive, empathetic, but also assertive. Both sides of the spectrum. We don't want them to be assholes, right? But at the same time, we also don't want highly passive neutrals, because this is a common complaint we hear a lot from plaintiffs, defendants, in-house counsel, law firms. The neutrals who just kind of take what they call the lazy approach, which is, just split the baby, or we'll just go half and half, right? We want neutrals to have a perspective. We want neutrals to like really challenge each side's cases and points of view, right? But do it in a way that's not abrasive, isn't condescending, and again, providing the parties a good experience during the actual kind of human arbitration and mediation. And then, so we do that on the front end, and we always collect feedback on the back end. We act on it. And so, there are certain folks, like one or two, right, that we've just kind of done less work with going forward because, hey, the feedback on them was abrasive. And it's like, well, we're fortunate to have a lot of neutrals who aren't that, who are also highly experienced in the relevant areas. And so, why put an abrasive person, into a dispute?
What are the requirements to be a neutral? I mean, because in theory, some mediators don't have law degrees. They have an expertise in whatever. What is New Era's background requirements?
There's some rough guidelines on our website, but we still take each person on a case by case, right? Certainly on the arbitration side, we're looking for practicing lawyers or retired lawyers. Typically minimum at least 15 years of actual practice. On the mediation side, that's where things, like you said, there's some more kind of subjective qualities that are really important. And so we have some folks, for instance, that we could put on, potential like real estate cases or anything related to housing, right? Where I think one or two of them I don't think they are JDs, but they know this space well. They have a way about them. They have a demeanor, and they of course have the knowledge, right, to kind of knowledgeably but empathetically navigate a conflict between two sides and hopefully actually help two sides see the other side's perspective so we could get to some sort of compromise. Still don't want somebody who's too green, right? And so we generally, don't have a lot of fresh out of law school or fresh college grad type folks, usually still hovering at that like minimum 15 years of practice.
Interesting. So let's talk about that. Let's go back to the claim you filed against me. We talked about earlier. What's the selection process? How do we agree on who's going to hear our dispute?
So the selection process is very much in the control of the two sides, right? So we never, in most cases, unless, there's a certain very niche dispute type that we've pre-agreed, we've kind of predetermined is like an appointment basis. In almost all circumstances, both sides choose, right? And so how they choose is we present a slate of like 6 to 8 handpicked neutrals. This allows us to at least control for experience, diversity, right? Diversity in every sense of the word, not just race, nationality, and gender, but, just kind of background, life experience, geography, age. If you have an employment claim, sometimes you maybe do want that like, late 30-something neutral or early 40s person, versus somebody who's a retired judge who was in their 80s.
Right.
But that's not up to us. We present the options. And then it's a very voir dire-like strike and rank process.
And it's all done online.
All done online, all done on our platform, all done, kind of programmatically. You go in, you rank, you drag and drop, the actual rank order. And then the highest rank wins, right, at the end of the rank process. Of course, there's strikes too. But one thing that we also do is we make sure the parties are limited in their strikes. So they can't, there's never an instance where the two sides can just strike all 8 people that we presented, because that's another thing that we're kind of designing to avoid is as we were launching, as we were, kind of researching this industry, another kind of common complaint among lawyers on all sides was like just the arbitrator selection process. Hearing about cases where it would take 6 months, 12 months. One person even told us that it was month like 15 or 16 and they still hadn't picked an arbitrator, right? And so avoiding that, right? And so our point is we will always have highly qualified, relevant, right? And so you won't have, let's say, an employment arbitrator hearing an auto warranty case or vice versa, because that person won't even be on your panel of 8 to choose from. So we control for that, right? But then the point is you all need to figure out, and you will end up with an arbitrator and we will move forward, right? If, God forbid, that ends up being a bad experience, you tell us about it afterwards and we will do something about it, right? But for each case as it's going along, that arbitrator selection process is designed to get to the point, get someone in that seat.
That's really cool. The online thing is so great. What are you not doing today that you're going to be doing in a couple of years, maybe a year, maybe 5 years? What's on the roadmap? What do you want to get into?
Definitely, stuff with a lot of the metadata, right, on these cases, and certainly, elements of people like to call AI nowadays. I mean, a lot of us come from data science and machine learning companies and analytics companies, which is basically AI before it is what it is today. It's just a lot of these large language models now allow us to, kind of parse unstructured data a little easier, to kind of turn it into structured data. But, we have those backgrounds, and that's something where everything we build and the stuff that we can build, using a lot of this metadata can be designed to then push parties to resolution potentially even earlier, right? And that's always the goal of kind of everything we do and everything we build is, can we find ways to even provide signals to one side or both sides?
How are you thinking about that? I know this is still something not necessarily totally the theoretical stage, but something you're talking about. Give me an example of some information you collect from your prior arbitrations on the platform that you somehow can use in a future one to push the parties closer together, or maybe even get them to resolve it. How are you thinking about that?
Well, I think like at a very basic level, right, just kind of giving historical data to both sides. Just say, hey, without naming names, parties, or individuals involved in the cases, just, previously in cases that were like yours, in this kind of employment case, they usually ended up right around here, right? So just so you all know, even though it's only a 100-day process, do you want to shorten that more? And just, hey, get to the point. And you know what? If you settle off platform, fine. We're not trying to make money off, the quicker settlement. Well, here's some data just to, give you some almost like real talk, but a data-driven real talk, so that both sides can take a look at this, and hopefully cooler heads will prevail and say, you know what, most cases are like this. My case, I don't think there's anything special about it. Maybe we do just kind of get kind of in and around this number that they see. And that's kind of one very basic use case.
Yeah, it makes sense too, especially when you have, like the auto company you talked about. When you got the same type of dispute over and over and over, you can really say, look, you consumer can fight about this, but historically, this is what's happened. So
right. And actually, that's an interesting part. And it's, we've now spoken to many auto companies, right? And kind of we're working through this with others. And I can tell you, like, one common thread that I've found, right, that like I think as an outsider, maybe I didn't know and I would have thought was the opposite. These auto companies actually all, like, their one goal is literally, like, I just want to do right by these people, right? And just either if I need to buy the car back, pay for the repairs or do something, we want to do it. It's just, once you kind of add in like a legal process, it starts to kind of muck things up. And so for them, it's like, well, let's just bring it back to, again, what I said earlier, just what's right is right. Like, let's distill it back down, simplify this, and so that way we can pay what we owe them, right? Oh, this car truly was a lemon. We got you, right? We're going to take care of it. And then on the other side, for the consumer, if you deserve a new car, you should get you a new car.
And using New Era is a hell of a lot easier for a consumer than it was with the prior iterations of this, right?
Yep.
Some probably Byzantine, like you can't get hold of anybody.
Exactly. And then I would actually add that it's also better for, the plaintiff's lawyers, right? Because for plaintiff's lawyers, a lot of times, plaintiff's lawyers often have to, there's an economic to it, right? A lot of them work on contingency. A lot of them need a percentage, right, of a settlement or an outcome, right? Which is kind of, how they earn money. But the thing is, like, in the past systems, because the expense of getting to that settlement or getting to that outcome, that the damages award, is so laborious and expensive, they could really only take on cases unscientifically, but like cases above a certain amount because they're running in their heads like, well, what's my percentage of X? And so X therefore has to be big enough to justify my potentially spending a year on this case or 2 years, right? If I can't extract a quick outcome. But that's not right. That leaves a lot of people unhelped. A lot of people who have, let's say, an employment, a $50,000 case, a $25,000 claim, they've truly been screwed. And $25,000 or $50K to an individual means a lot.
Yeah, absolutely.
But unfortunately, there are a lot of lawyers, and I mean, business is business, so I understand they can't take that right now. But this actually opens up a whole kind of swath of cases for all these plaintiffs' lawyers, right? Whether it's employment, whether it's warranties, or whatever, to take on these like kind of smaller dollar cases, right? They just have to be meritorious. If they're meritorious, you take these on, you're going to collect far sooner. You're going to be able to help a person, so more people can be helped, but then, the plaintiff's lawyers can actually, almost like supplement their income and add to their income, because this whole long tail of disputes that currently they were just walking away from because it wasn't, quote unquote, worth their time. And now when it's 100 days, maybe that calculus completely changes, right? It's, maybe it is worth their time now to take on that $25K claim because it's going to be done in 100 days. The only thing it has to be is meritorious. If it's not, you're going to lose fast and you'll walk away with zero.
That's even better for a plaintiff's lawyer, right?
Yep.
Because but better to lose on day 7 versus day 422, right?
Yep.
After you put all this human time and been to court 5 million times and filed 20 different motions,
And then same with the companies. Companies are dealing with a lot of frivolous ones. And so those should fall away, right? And then again, what's right is right. And the ones that are in the middle, well, that's what the arbitration's for. Somebody will win, somebody will lose. But the truly meritorious defenses they have, guess what? Now they're going to work, and they'll work, within 100 days instead of over 2 years, forcing you into that question of well, I know I have a strong defense and we would win this, but, still paying a nuisance settlement anyways.
Rich, great to have you back. It's good talking to you. If people want to get a hold of you or learn more about New Era, where do you want to send them?
Well, New Era's website is neweraadr.com. And, my email is rich.lee, Lee, at neweraadr.com.
Okay, that's a wrap for today's episode. As always, we really appreciate you listening. If you want to subscribe, you can find us on most major podcast platforms like Apple, Spotify, Google, Stitcher, etc. Also, if you like us enough, I hope you leave us a favorable review. Thanks again for listening. Until next time, this has been Technically Legal.